Hello, everyone. Welcome to the Right Constable and Skeen webinar on Senate Bill 853. My name is Doug Seitz, and with me are my law partners, Cindy Rogers-Ware and Greg Curry. We're going to talk about this bill by breaking it down into three different topics. First will be a description of the law. Second will be talk about actions brought under the wage payment and collection law. And the third topic will be ways a general contractor can protect itself from the ramifications of this new law. I will be handling part one, Greg will be doing part two, and Cindy will be doing part three. If you have questions, please go ahead and submit them, and we will try to get to them at the end of the webinar. Okay, so let's flip over to yes, thank you. So my part of the webinar is just to talk about what this new law is, and I wanted to start the discussion with an observation made 60 years ago. On the screen is a quote from Chief Judge Thompson in a Miller Act case in the United States District Court for the District of Maryland. And this quote points to the potential problems that may be encountered due to the introduction of Senate Bill 853. What Chief Judge Thompson is saying is that there are so many layers and moving parts of a construction project that it is impossible for a general contractor to be in control of everything. And that was true 60 years ago, and it's, I think, even more true today. And that's pretty much the gravamen of the problem that's going to face general contractors as a result of this bill. What you see next is a floor report that was issued by the Senate Finance Committee that was where this bill came through. Why I put this in, it's a nice summary of the law, even though it's not 100% accurate because there was an amendment to the law before it was ratified based on a House bill that changed it slightly. But let's just go through it quickly so you have a decent idea of what this law is addressing. So what they did was they took an existing wage payment and collection law right for employees to sue their employer and obtain certain damages, and they added to that law the ability for that employee to sue not only the employer but also the general contractor on a construction project. Then the second part of the bill affords a little bit of protection to the general contractor by saying that the general contractor can be indemnified by the subcontractor that didn't pay the wages. And by indemnification, we mean that whatever the general contractor has to pay out of pocket as a result of the failure to pay the wages or the violation of the Wage Payment Act, it could recover from the subcontractor that didn't pay those wages. So the slide shows what the existing law looked like before SB 853 was passed. And I won't go into it. Greg will certainly get into it a little bit more. But the one thing you will note is under subsection B, it outlines what damages the employee can sue for. And the two big things are the amount of the wages times 3. So whatever wages were not paid, multiply that times 3, plus reasonable attorney's fees and other costs. Those two, although possibly the wages are not particularly onerous to a general contractor, the attorney's fee issue could certainly be. In addition, the fact that this would be multiplied on a construction project many times if the subcontractor wasn't paying all of its employees, or if other subcontractors on the project weren't paying their employees as well. So you could have easily the snowball effect in these situations where a general contractor could be looking at substantial damages associated with the failures of remote subcontractors not paying their employees. Okay, so let's look at the Senate Bill 853 in a little bit more detail. Basically, 853 is going to insert a new section into the wage payment and collection actions section of the code. Subsection C is then broken down into 3 subsections, and the first of which is a definition of construction services. This construction services, as we'll see, is a critical part of the 853 law. And what the legislature has done is they have taken a definition from another section of the Labor Act in the code and incorporated that definition into this section of the law. But what's important to note is this is the only critical term in this law that's defined. And there are other very important terms that are not defined by this new law. And what we're looking at now is the second section of C under Senate Bill 853. And the second section is primarily the guts of the law. And it pretty much says what the floor report said, but going through it, it basically says that if an action is brought for the failure of anyone on the project to not pay its employees, then in that action, the general contractor on the project, who may not have any connection whatsoever with that subcontractor, in other words, it's not a direct subcontractor of the general contractor, it could be a very lower tier subcontractor. Nevertheless, the general contractor will be jointly and severally liable for any damages that are awarded in that case, and can be named as a party in that lawsuit. The third section of Section C deals with the indemnification that I talked about briefly in the beginning. Basically, what it says, with some rather limited or obvious exceptions, that the general contractor has a right of indemnification, in other words, a right of action against that subcontractor who did not pay its employees. The exception is there's 2 of them, and they're set forth at the bottom. And basically, they are if there is an indemnification agreement already in place then that indemnification provision would override the statutory indemnification. The second exception is very obvious, and that is if the failure to pay the wages resulted because the contract price was not timely paid to the subcontractor who didn't pay the wages, then indemnification wouldn't kick in. The problem with that is it may not be the general contractor who violated the Prompt Pay Act. It may be that the owner hasn't paid the general contractor for the amounts that were due to the workers, or it may be that a lower tier subcontractor held the money and didn't pay. It's not clear there whether those situations the general contractor would still not be able to have indemnification. The other thing that I want to point out about indemnification is that what we anticipate happening are these are very lower tier subcontractors that aren't paying their employees. And the question is, if these subcontractors are not paying their employees, whether they would even have the wherewithal to pay the general contractor for whatever the general contractor is out of pocket. And Cindy will talk about that later. The final part of the bill is just two sections. One says that the act will take place, will go into effect October 1st. The first one says that it won't change any existing obligation or contract right. I'm kind of at a loss as to what that exactly means, other than maybe this can't go backwards on general contractors, but someone else will flesh that out. So basically, general contractors, I would say subcontractors, possibly subcontractors, have about 3 months to figure out how they can address the potential issues and liability that could be associated with this change in the law. Okay, now I'd like to talk about definitions again. And the first is the definition that was defined under the Act. And it is the definition of construction services. So what the Act says that in an action brought under subsection A of this section, a general contractor on a project for construction services is jointly and severally liable for a violation of this subtitle. Okay, so what becomes critical is, well, there's certain items that become critical. First of all, what is a general contractor? What is a project for construction services? And what is a subcontractor? So the first part of that, construction services, is defined as construction services includes the following services provided in connection with real property. First, building. Second, reconstructing. Third, improving. Fourth, enlarging. Fifth, painting. Sixth, altering. 7, maintaining. And 8, repairing. Well, let's just break it down, first of all. First of all, construction services is not completely encapsulated in that definition because it says includes. So therefore, it arguably, a plaintiff could argue that is not limiting just to these 8 things, that it could be other things, which could potentially be a problem for suppliers that have wage payment problems? Could a supplier be pulled in into the project under this definition? Not certain, but the next critical part, services, would say no. A materialman supplies materials, goods, not services normally, but I would still say it's open to conjecture. Then we go down to the 8 things that are involved in connection with real property. Building, reconstructing, that's obvious, but painting, altering, maintaining, repairing, I think these type things open this up to the non-traditional construction project things. For example, an existing building that has its cooling system repaired. I mean, does that create liability, and for whom? Who would be the general contractor when a building manager hires an HVAC company to work on the cooling system and the HVAC system doesn't pay its employees? Is that potentially something that could be encapsulated in this act? I don't know the answer, but I think it's a good question. There's no residential exclusion on this law, so would home improvements be involved? I don't know. I mean, to me, they certainly will be. So let's get to the worst thing, which is the undefined terms. And the 2 biggies are general contractor and subcontractor. General contractor, there's no good definition in either the Maryland Code or the Maryland regulations on what a, quote, general contractor, unquote, is. There are definitions, however, of contractor. And I think it's fair that they could be relied upon to determine what a general contractor is under this law. The best one that I thought, the most applicable one that I could find, was under Maryland's Mechanics Lien law. And that has both a definition of contractor and subcontractor. Unfortunately, because of the nature of the Mechanics Lien law, the idea being that the law was drafted broadly in order to provide a remedy for many people in the trade that weren't paid on a construction project, these 2 definitions are very broad. And as you can see, contractor means a person who has a contract with an owner. Okay, that is a pretty short definition, because as we know, there's these things called construction managers running around. And construction managers run the gamut of what they do with regard to a construction project. There are ones that don't have any contracts with anybody on the project other than the owner. So by this definition, wouldn't that construction manager be a contractor? I don't know the answer to it. That's going to be a question. Let's look at subcontractor. Subcontractor means a person who has a contract with anyone except the owner or its agents. So, again, subcontractor under the Maryland Mechanics Lien law definitely means that material men, suppliers are deemed to be subcontractors. Does that bring them into this law? Does that mean that a general contractor has to worry about whether a supply house has paid all its employees? It's unlikely, but the definition of construction services is not a great definition, especially with includes being in that definition. But what it definitely means, and the law as amended, definitely indicates is that the general contractor is responsible for all the subs on that project, no matter how remote. If they are on that project doing work, then the GC is going to be responsible for ensuring that every employee gets paid the wages that they are entitled to. I revert back to what Judge Thompson said 60 years ago. That is a formidable task for a general contractor. My conclusion is that general contractors, and Cindy will get into this, will push this burden downhill, and so that subcontractors have to be prepared when this responsibility is pushed through indemnification upon them. Subcontractors need to figure out a way to push this responsibility further downhill. And what's going to result is that it's going to be a legal nightmare as to who is responsible. Okay, now we're going to move on to Greg.
All right, my piece is talking about, so, Doug gave a great overview of what the law is. And so what I'm here to talk about is from a labor and employment perspective, what an action under the wage payment and collection law looks like, and what employers or general contractors can expect some of the big issues to be from their subcontractors. The Maryland Wage Payment and Collection Act applies to any claim for wages, not just a failure to pay on time. That includes unpaid overtime, improper deductions, failure to timely pay wages, and misclassified employees. There are two wage payment laws in Maryland. There's the Maryland Wage and Hour Law, which governs minimum wage and overtime, and then there's the Maryland Wage Payment and Collection Act, which governs governs how an employer actually has to pay their employees in terms of setting regular work weeks, in terms of timely paying, final paychecks, in terms of how much of a lag time you can have between when the wages are earned and when they actually have to be paid. And so it's not just, oh, I didn't get paid at all kind of claims that are covered by the Maryland Wage Payment and Collection Act. It also includes failure to pay overtime. If you have an exempt employee, if you've designated an employee as exempt so that they don't get overtime, but then the court comes back and says, oh no, this person based on their job duties was actually non-exempt and you owe them all of this overtime, that then falls under the Maryland Wage Payment and Collection Act, even though it originally arose under the Maryland Wage and Hour Law. So these are some of the very sort of frequent kinds of cases that we see. And unpaid overtime is probably the majority of the cases that we deal with. But you do have to look out for improper deductions, failure to pay on time. I can tell you that a lot of times when I'm looking at employee contracts or employee handbooks, there are provisions in there that say, if you don't return all company property, we're going to hold your final paycheck. That's illegal. If you may have situations where employees are docked pay for mistakes on the job or costs for repair. If those are improper deductions that aren't authorized under the law, taking those deductions can give a rise to an action under the Maryland Wage Payment and Collection Act. So you need to make sure that all of your pay practices are compliant with the law, not just, okay, this guy got a paycheck every 2 weeks, we're fine. That's not going to be enough. You're really going to have to dig into the underlying, were they paid not just on time, but were they paid correctly for all the time they actually worked? So looking at the Maryland Wage Payment and Collection Law, many contractual defenses are not going to apply to an action under the Maryland Wage Payment and Collection Law. So for example, if you're a general contractor who has a pay when paid agreement with your subcontractor, that's not going to protect you from an action by a subcontractor's employees who aren't paid on time by the subcontractor. Agreement if you have an agreement in place with your subcontractor where their employees are prohibited from working overtime, you can have that contractual provision, and maybe that'll be a defense or give you a right to an action against the subcontractor, but it doesn't prohibit the subcontractor's employees from being paid for that overtime. What about a situation where an employee says, look, I need the extra hours, I need the extra money. I know you can't afford to pay me time and a half on this project. I know the budget is tight, I know we're close. So I'll work the extra 10 hours so you don't have to give it to somebody else, and you can just pay me straight time. I see this all the time with employers, and unfortunately, the courts will not enforce that agreement against the employee. The employee who agrees to this is selling you a lemon, because once the project is over, they leave employment, the relationship with the employer falls apart, they're going to come back and sue you for the unpaid overtime premium of the extra time and a half for those hours that they worked at straight time. Last piece are undocumented workers. I can't tell you how many employers I work with that an employee's terminated, a lawsuit's filed, and they come back and say, well, these people weren't documented workers, they're here in the country illegally. Let's just raise that as a defense, and then we won't owe them the money. The courts routinely deal with this issue. It's an issue that's been dealt with time and time and time again. And what the courts say is that you as the employer who hired this person, you're responsible to pay them regardless of their immigration status. There may be some limitations in terms of, under the labor law, whether or not they're entitled to reinstatement or back pay in the case of retaliation. But at the end of the day, if they worked hours, they're entitled to payment for those hours, regardless of their immigration status. So what are some things you should be watching out for if you're a general contractor and you're worried about liability under this act? Big one on construction projects is, are employees properly being paid for travel time? Travel to work from home is not compensable. Like, everybody knows that rule. But what about when an employee is traveling from job site to job site? Or when they're picking up tools at the yard and then traveling to the work site? Or maybe you've got a mandatory carpooling program where the site superintendent gets a company truck, but, well, he lives near some of the other employees and they don't have reliable transportation. So you say, as a condition of getting this company truck, you have to go pick up all the employees on the way to the site. In all of those situations, that travel time is now going to be compensable. For carpooling, generally speaking, if you're requiring somebody to participate in the carpooling program, you're going to have to pay for that time. If the carpooling program is for the convenience of some of the employees, so for example, you've got the site superintendent, they're stopping and picking up 3 people on the way to work because they don't have reliable transportation. Generally speaking, the site superintendent who has the company vehicle and is being required to pick everyone up, their time will be compensable, but the time as a rider will not. As a general contractor, if your subcontractors are engaged in these kinds of practices, you may not know what kind of hours the subcontractor's employees are working. And so it's going to be important that they're clearing any of these practices with you beforehand. Because as a general contractor, you may only know, okay, the job site is open for these hours, and these are the hours that people were there working. And so I'm comfortable that if they got paid for those hours, that they were properly paid. Well, if you don't know, where did these people report? Did they show up to the job site first? Did they go somewhere else and do another side project for the employer, for the subcontractor? You need to be aware of these kind of situations. Another big issue we see on construction projects are meal breaks. Many employers will have automatic payroll deductions in place for meal breaks where they say, okay, everybody, you get a half hour for lunch, and for administrative purposes, because it's hard to have a time clock on the site, if you clock in at 8 in the morning, you come back and clock out at 5 p.m., we give you an hour for lunch, and so we're just going to take out that hour from 12 to 1. But then one day, everything's busy, or you're getting near the end of the project, you're on a time crunch, and people are working through lunch, or they're taking only a half hour instead of the full hour. And so instead of actually working 8 hours, they're working 9, but the automated payroll deduction is telling the employer that they're only working 8 and they're only paying them for 8. And so if it's an hour a day that they're working through at the end of the week, on a standard 5-day work week, there's 5 hours of unpaid overtime. And over the course of a project, that can build up and create a significant amount of legal liability. And I'll talk in a few minutes about how these things multiply very quickly. The next piece on meal breaks are employees who are not fully relieved of their duties. So you've got an employee sitting at their desk, or they're working on a project, or taking calls while they're eating. If an employee is not fully relieved from their duties while they're on a meal break, they need to be paid for that time. And the last one is a simple one, but it's employees not actually recording breaks. So an employee comes in the morning, they take an hour lunch, but they just write on their timesheets, I came in at 5, I left, or came in at 8, left at 5. They took an hour lunch, but they didn't write it down. Or they didn't take an hour lunch, but they wrote it down anyway because they were told they had to write down that hour-long break. In those situations, you need to be aware of what your subcontractors are doing and what their employees are doing to make sure that you're not running up a tab for unpaid overtime that you had no way of knowing about. And I can tell you, the employee that was told not to work overtime or told to record their meal break, but they actually work through it, it happens more than you think. And so you can end up with these situations where, you go into the court, you've got a company policy that says everybody gets an hour-long lunch, and the employee is saying, no, that policy wasn't followed. And that's going to create an issue where you're going to end up either paying a lot of money to settle the case, or you're going to have to go to trial to figure out what hours did the people actually work. Another issue to look for are misclassification issues. Are your subcontractors properly classifying their employees as exempt or non-exempt? Because remember, not all supervisors are exempt managers. The duties test for an exempt manager is more strict than just, oh, you supervise some employees. You have to have at least 2 employees that you have direct supervisory control of, and that has to include control over terms and conditions of their employment, disciplinary issues, hours worked, wages. So, for example, if you've got an assistant manager or a site superintendent that's sort of they're in charge of making sure everybody's doing what they're supposed to, but they don't really have a real authority to independently enact discipline or independently change what the employees are doing, they may not qualify as an exempt manager under the FLSA. And so then you may be having these employees out there working a lot of overtime that they're not being paid for, and that if later challenged, it's going to turn out that they're non-exempt and they're owed the overtime payments. The last issue is misclassification of independent contractors. I mean, this is a big issue in the construction industry already, but you need to be careful that your subcontractors aren't bringing other people on and just paying them as independent contractors to try to get around the wage and hour laws, whether that's by paying them at a day rate, regardless of the hours they work. I see it a lot in the immigration context where an employer says, well, this person isn't here legally, they can't fill out an I-9 form, so I'm just going to classify them as an independent contractor so I don't have to get the immigration paperwork, and then I'll just pay them $50 a day. And they work a 12-hour day, the project's over, and they file a lawsuit saying, I was paid 50, 80, whatever dollars a day. I was working 10 to 12 hours a day. I'm owed all this extra money. So what are the costs? The costs can multiply because when we talk about the treble damages and attorney's fees, the treble damages make getting things wrong very expensive for employers. There's no rule of proportionality for attorney's fees. Early on when this law was enacted, the Maryland Wage Payment and Collection Law was enacted, there were challenges where there were cases where the dollar value of the unpaid wages was relatively low. And so the case would go to trial, and a judgment will be awarded, and then the attorneys for the plaintiff file their petition for attorney's fees, and it dwarfed the dollars involved that were owed to the employee for wages. The Court of Appeals looked at this on on appeal once, it got sent back down, it came back up again, and the court set out a clear rule that there is no rule of proportionality for attorney's fees in these cases. And so you may have an employee with a $5,000 claim, but if that case goes all the way up to trial and you've engaged in expensive discovery and motions practice, they may have attorney's fees of $50,000. And so the judge awards them $5,000, and then you have to pay their attorneys $50,000 on top of what you already paid your attorneys as well. As far as the treble damages are concerned, the definition of what is a bona fide dispute as a defense to the treble damages, it's very narrow. And what you're talking about are good faith mistakes, whether that's in terms of the law or the hours worked. If you are going into court and you're saying, and you look at it and you say, oh, this person is definitely owed the money, we had an issue with our payroll, that's not going to be a bona fide dispute. If you go in and you say, oh, well, I thought they were exempt because I paid them a salary, but I never got an attorney's opinion on that, that's not going to be a bona fide dispute. Bona fide disputes are very limited, and so you have to be very careful, because the law is that if you suffer or permit someone to work for you, you are responsible for making sure that their hours worked are tracked and are accurate. And so if you just say, well, I didn't know what hours they were working, the judge or the jury is going to look back at you and say, well, why didn't you know? Why didn't you put in a timekeeping system? Why didn't you monitor these things more accurately? And so that's going to be a problem. With these treble damages and attorney's fees, small claims can get expensive quickly. And that's why it's so important to get things right from the beginning. I don't know how many of you watch sports late at night, but you'll see the commercials for the different wage and hour law firms that are working for employees. For those of you who have been around the legal industry for a long time, you may recognize the names of those law firms as being formerly the asbestos law firms or a lot of the big personal injury law firms. They've gotten into this because you get these attorney's fees. And so a lot of times when you're dealing with some of these law firms, they will, as part of any settlement offer, regardless of how early the settlement offer is issued, they will insist on the full freight of their fees through trial, even if you're settling from day one. So you want to get this right from the beginning. The bona fide dispute defense is going to be an interesting issue in the context of this law. The courts are judges have a lot of discretion to determine what is or is not a bona fide dispute. And so we're going to probably see a lot of issues in terms of what was the general contractor required to do to ensure that the subcontractor's employees were getting paid. And because the general contractor is going to have joint and several liability with the subcontractor, we're going to see questions of, is the general contractor entitled to raise defenses to the claims that the subcontractor may not have been able to raise? For the next piece of this presentation, Cindy's going to go over some of these protections that the general contractor should take to ensure that they're not hit with damages, and if they are hit with damages, hopefully they can avoid the treble damages component of the law.
Yes, now that my two partners have sufficiently scared you with all the doom and gloom of what this law might entail, now we turn to the section of trying to see what a general contractor can do to try and protect itself to the greatest extent possible. The first piece of this is just going to have to do with the vetting process of subcontractors before you enter into any subcontract with them. You may consider doing something like a survey or a questionnaire. This is common in sort of the federal world of procurement, where the government sort of vets contractors in their pre-award surveys and things like this. Maybe some general contractors already have something like this in place. Maybe you don't, but it's certainly worth putting it out there And one of the specific questions you would ask is, of course, that do they have any prior wage violation claims or lawsuits? You know, it's better going in knowing whether this subcontractor is sloppy or not in its labor and its record keeping, or whether it's running a tight ship and doing things the right way. So some history of prior claims and issues is going to be some indication of what kind of subcontractor you're dealing with. One of the concerns, of course, with this law is, you know, if you might get indemnity, but as we know, indemnity may not be worth something if the subcontractor has financial issues. So the other thing you may want to look into closer than you do now is the financial health and status of that subcontractor. Now, I know that's not always the easiest thing to do, and you're going to get some pushback on that, but certainly a lot of subcontract agreements make a subcontractor warrant that they have the financial capacity to do the work and so on and so forth. So this is somewhat a corollary of that is, you know, we want to make sure that they have the financial wherewithal to deal with this if a wage and hour law issue is their responsibility. And finally, there's an old expression of the words trust but verify. I think that applies here as well. There are records that, you know, there are court databases. You can probably go out and look online and see if there is any court records of any prior issues and just sort of vet the subcontractor to see how much litigation this particular entity has been in the past. And obviously, if there's something involving the Department of Labor, that would be of significant concern. Now, my partners have already mentioned that the statute has an indemnification provision. I like to think that we should take the sort of belt and suspenders approach. I believe that it's important to have indemnification language in the subcontract agreement itself for a couple of reasons. One, I'm not exactly sure that the language of the statute is overly clear. So it just says subcontractor. You get indemnity from the subcontractor. Okay, is that your direct subcontractor who may or may not have been the one who violated the statute? Or do you get indemnity from a subcontractor or a subcontractor who was the actual guilty party here? I don't think the law is very clear. So in that scenario, and just to make sure that your direct subcontractor is on the hook because your subcontractor is responsible for everyone downstream, you need to have indemnification language in your direct subcontract. A lot of subcontracts have indemnification language now. I don't know that it all is broad enough to cover this scenario. Back in the old days, indemnification provisions basically said things like, you know, you have to indemnify us for a loss, that a personal injury or an illness on the site or damage to the property damage. So that's not the kind of indemnification that would really cover this type of scenario. So I think you've got to look to expand the language in any indemnification that you do have that would specifically address the issues here, including like any kind of wage and hour statutory violation. Plus, if there are going to be subcontractors on the job, you're going to want to put language in there that tells the subcontractor to include similar language in their subcontract agreement, and to make sure that the indemnity in that subcontract agreement also indemnifies the general contractor, not just the subcontractor. So that's very important to sort of carry that language downstream to make sure that the general contractor is fully protected. The other thing I think is you need to be aware, and a lot of times general contractors aren't aware or they don't necessarily think it's important, of whether there are other, lower tiers. You may sub it out to a subcontractor and not realize that they have subbed it farther downstream. So I think that you either need to have a prohibition on that being done without your consent, because really general contractors, I mean, they're busy enough that just even trying to vet the first level of subcontractor, it's very difficult to have the time or incur the expense of trying to vet even farther downstream. So I think, and as Doug sort of alluded to, the farther downstream you get, it's usually smaller companies, less sophisticated, may not have as much knowledge of wage and hour law, and I think the risk goes up as you go farther downstream. So you want to have some kind of provision that the subcontractor has to get approval from you first, and make you aware and get your approval to even have a subcontractor scenario. Like Doug said, I'm not sure whether suppliers are covered by this law. I'm really hoping not, because the idea of even vetting to that level, I think, starts to get impossible. But at least from a subcontractor and someone who would actually be providing labor, I think you need to have some more control over that situation. The next thing that you may want to consider is requiring the subcontractor to provide certified payrolls and have a lower tier provide certified payrolls. These are very common and generally required on public construction projects because of compliance with statutory wage and hour law. It's not normally a requirement on private construction, but it may show some, give you some extra protection and give you some records about what employees were actually providing labor on this project. Now, I recognize that for the records to be protected or have some protection for you, they have to be accurate. So if you're getting, it's kind of a garbage in, garbage out, but it could provide you some layer of protection to police that employees are getting paid and that they're getting paid properly. It doesn't necessarily have to be a certified payroll. It could be some other form of documentation of labor being paid in whatever format the parties could agree to. The next issue is being able to access those records after the fact. This statute allows 3 years for someone to bring a claim. This is not, we're not going to be dealing with your employees. You're talking about somebody else's employees. You're not going to have the records in your possession in the absence of some kind of certified payroll requirement. So you need to make sure that your subcontract requires the subcontractor and any lower tier subcontractor to preserve those records for a sufficient period of time that they're still going to be accessible later to be able to review in defense of one of these claims. You also want to have the right to be able to go in and review and inspect them timely. So if this claim comes up, you need to be able to be given access to it without having to necessarily go through some formal litigation discovery process. So contractually, you want to have a right to be able to inspect those employee records. And again, this needs to be a provision that gets covered into any lower tier subcontract as well. And of course, it goes without saying you need to keep your own records for sufficient time as well. So I would say, with a 3-year statute, I would say, you'd probably want to have someone preserve them for at least 4 years in some format, whether it's electronic or paper, it doesn't really matter as long as there's a way to access them after the project's done. The next thing I consider is whether, and this ties into something I'll discuss further with surety bonds, but whether you have a definition of default in your contract or material breach, and list some contracts list out specific grounds, others sort of leave it vague. But if you're going to have a list of grounds, you want to make sure that a violation of statutory requirements is included. One, you may want to have the right to terminate a subcontractor that's already, if you're getting claims during the project, this might be a subcontractor you want to get off the job sooner rather than later. But it also ties into whether you can trigger a surety bond coverage if you've opted to have that subcontractor be bonded. Lien waivers. A lot of lien waivers are just providing you're paying me this much, I release you from any liens for that amount and any amount that I've already been paid. You want to consider, just as a way of emphasizing, that you have language in your lien waivers that has an affirmative certification that subcontractors have paid for their labor and that they have paid their lower tier subcontractors from the money that they have already received, and that they will pay them from the money they're receiving with that payment application. Also, I know sometimes general contractors can get a little lazy about making sure that they're getting lien waiver forms from tiers farther down, particularly in a situation where, okay, well, if I know that a third tier subcontractor can't do a mechanics lien, I don't really need to get a lien waiver form from them. Again, if with this language and these representations, I think it's important to make sure that you're requiring lien waivers from every tier down. If for no other reason that it might make you aware of a subcontractor that you didn't, or a subcontractor that you didn't necessarily knew was performing work on your project. So if you do have one of these claims, what are your potential sources of recovery beyond the indemnification language in your subcontract agreement? Well, one is to require that a subcontractor provide surety bonds. Now, that's not always possible. Not all subcontractors have bonding capacity. But where they do, it might be worth considering that as a possible source of recovery in the event that a subcontractor cannot pay under the indemnification. The surety company could potentially be on the hook for this being sort of a breach of the contractual obligations. Now, every bond form, there are literally thousands of different bond forms. There are certain industry standard ones, but people also create their own bond forms. So, to go into the language of what those forms would be well beyond, an hour webinar. But one of the things you do have to be aware of is a lot of bond forms do have a provision about, that liability is not triggered unless there is a default. So you have to be mindful of that within your subcontract and what would constitute a default. Bond forms also may spell out what types of damages are recoverable. So it may be that the actual wage underpayment is covered by a bond, but the treble damages, attorney's fees may or may not be, depending on what's written in the bond form and your subcontract. The other thing to be mindful of with surety bonds is they typically provide notice provisions about when the deadline is for making a notice of a claim against the bond. They also may have contractual statute of limitations provisions about how long someone can have to file suit. There's also, on public projects in Maryland, the Little Miller Act, which also has its own statute of limitations as to when a suit against a bond could be made. Another potential source of recovery is to require a subcontractor officer or owner to provide a personal guarantee with regard to this issue. Again, it's going to be a judgment call depending on your vetting of the subcontractor, their background, their financial status, their general reputation in the industry as to whether you think that a personal guarantee from an individual owner or officer would give you a greater level of protection if for that indemnification provision to kick in. Another potential outcome of this would be a scenario where the contract funds don't go directly to the subcontractor. Now, this would be a very administratively burdensome task. This gets done sometimes in the surety situation, where a surety requires contract funds to be placed in an escrow or a funds control account so that the surety has a say as to making sure that the monies get paid to the parties who are owed. A similar type situation could happen between a general contractor and a subcontractor for the general contractor to basically has to pre-approve payments to make sure that subs are getting paid and employees are getting paid. I don't know that this would be a super popular option considering the expense and effort, but it is a potential situation to address this exposure. Maryland does have a trust fund statute. So in terms of trying to seek recovery of a loss from someone other than the specific contractor, there's a potential to go after the individual within that entity that did not make the payments. The law, there is some case law under it. There's not a lot, but there are situations where if someone inside that subcontractor knowingly and intentionally diverted the contract funds to pay other things, then there is a potential for that individual to have personal liability under the trust fund statute. Now, one of the big question marks is insurance coverage. This is a very new law. Obviously, it hasn't even taken effect, but it is valid. It's passed. It will kick in October 1st, as we've indicated. I am not aware of any existing insurance coverage that would cover this, but the insurance industry is just sort of becoming aware of this. And generally, if there's a demand for a certain kind of protection, eventually the industry usually finds a way to come up with some form of coverage. It's hard to know what that would be in this scenario or the cost, because I think in some ways it's difficult to gauge the risk when you have a situation where there are treble damages and legal fees, but we're kind of at a wait and see on this to see whether there's going to be an insurance product out there that can be purchased. The bottom line of all of this is it's going to drive up construction costs because there's going to be a lot more administrative issues involved. If you're purchasing more bonds or insurance than you were originally anticipating, all of that is going to factor into cost. That wraps it up for us. If we have questions and have some time, we'll go through those now.
So I know we went through things pretty quickly. I'm not seeing any questions through the systems, but all of our contact information is on the final slide. So if you have, a week from now, something pops into your head, please feel free to email us. We'd be happy to talk over these issues with anybody that's got further questions. Thank you for your time this morning, and hopefully everybody's ready for the new law starting October 1.
Thank you.
Thanks. Well, that worked.